Introduction. When transactions turn into disputes. Even when agents follow proper procedures, disputes can arise in commercial real estate transactions. These disputes may involve contract terms, agency relationships, disclosure failures, or financial disagreements. Because commercial transactions often involve larger sums of money and more sophisticated parties, conflicts can escalate quickly. Understanding how to manage disputes, and more importantly, how to prevent them, is a critical skill for every real estate professional. This section focuses on dispute resolution methods and the legal risk management strategies that protect both clients and licensees. Common sources of disputes in commercial transactions. Commercial real estate disputes often stem from misunderstandings or failures in communication. Common issues include disagreements over contract terms, failure to disclose material facts, misrepresentation of property conditions, lease disputes, commission disagreements, and breaches of fiduciary duty. Many of these disputes could be avoided with clear documentation and proper disclosure. In Arizona, case law such as Hill v. Jones, 1986, reinforces the duty to disclose material facts, while Jennings v. Lee, 1969, highlights the fiduciary responsibilities owed by agents to their clients. Contract disputes and enforcement contracts are the foundation of every real estate transaction, and disputes often arise when parties interpret contract terms differently. In commercial real estate, contracts can be highly customized, increasing the likelihood of ambiguity. When a dispute occurs, the terms of the contract will typically govern how it is resolved. This may include provisions for mediation, arbitration, or litigation. Ensuring that contracts are clear, complete, and properly executed is one of the most effective ways to prevent disputes from occurring in the first place. Mediation, a first step toward resolution. Mediation is often the first step in resolving real estate disputes. It involves a neutral third party who helps facilitate a resolution between the parties. Mediation is typically less formal, less expensive, and faster than litigation. Many commercial contracts include mandatory mediation clauses, requiring parties to attempt mediation before pursuing legal action. For agents, mediation provides an opportunity to resolve disputes while preserving business relationships and avoiding the costs associated with court proceedings. Arbitration, a binding alternative. Arbitration is a more formal dispute resolution process in which a neutral arbitrator hears evidence and makes a binding decision. Unlike mediation, arbitration results in a final determination that is enforceable by law. Many commercial agreements include arbitration clauses to avoid the time and expense of litigation. While arbitration can be more efficient than court proceedings, it still requires preparation and legal representation, making it important for agents to understand the implications of these clauses when drafting or reviewing contracts. Litigation. When disputes escalate. When disputes cannot be resolved through mediation or arbitration, they may proceed to litigation. Litigation involves filing a lawsuit and resolving the dispute through the court system. This process can be lengthy, expensive, and unpredictable. In commercial real estate, litigation may involve complex issues such as breach of contract, fraud, or negligence. Agents should always aim to avoid litigation by resolving disputes early and maintaining thorough documentation of all transactions. Risk management through documentation. One of the most effective ways to manage legal risk is through proper documentation. Maintaining complete and accurate records is not only a best practice but also a legal requirement under ARS, paragraph 32-2151.01. Documentation should include agency disclosures, contracts, amendments, communications, and any other relevant materials. In the event of a dispute, these records serve as critical evidence and can significantly impact the outcome of the case. Disclosure as a risk management tool. Disclosure is one of the most important aspects of risk management in real estate. Failing to disclose material facts can lead to both disciplinary action and civil liability. Arizona case law consistently reinforces the importance of disclosure, particularly when defects or issues are not readily observable. By providing full and accurate disclosures, agents can reduce the likelihood of disputes and protect themselves from legal claims. Professional communication and expectation setting. Many disputes arise from poor communication or unmet expectations. Agents must clearly communicate with their clients about the transaction process, potential risks, and their role as a real estate professional. Setting realistic expectations and documenting those conversations can help prevent misunderstandings. In commercial real estate, where clients are often investors or business owners, clear communication is essential to maintaining trust and avoiding conflict. Real-world application. Commercial scenario. Consider a situation where a commercial tenant enters into a lease agreement based on representations about the permitted use of the property. After signing the lease, the tenant discovers that zoning restrictions prevent their intended use. If the agent failed to verify zoning information or misrepresented the property's permitted use, this could lead to a dispute or legal action. This scenario highlights the importance of due diligence, accurate representation, and proper documentation. Bringing it all together, preventing problems. Before they start dispute resolution is an essential part of real estate practice, but the best strategy is prevention. By focusing on clear contracts, full disclosure, accurate documentation, and strong communication, agents can significantly reduce the risk of disputes. In commercial real estate, where transactions are complex and high value, taking a proactive approach to risk management is not just recommended, it is necessary. In the final section of this chapter, we will bring everything together and focus on best practices for long-term success in commercial agency. Online discussion. What is the most effective way to prevent disputes in commercial real estate? Answer: clear contracts, full disclosure, proper documentation, and strong communication. Why is mediation often preferred over litigation? Answer: it is faster, less expensive, and helps preserve business relationships. How does documentation help in dispute resolution? Answer: it provides evidence to support claims and clarifies what occurred during the transaction.